Welcome to our channel, where we delve into the often complex and challenging world of U.S. visa immigration and denials and the avenues available for those seeking to appeal these decisions. Navigating the intricacies of U.S. immigration law can be daunting, especially when faced with the disappointment of a visa refusal. However, understanding the reasons behind a visa denial, the potential for a waiver of ineligibility, and the options for appeal can empower applicants to take informed steps forward. In this comprehensive guide, we'll explore the critical aspects of understanding the specific reasons for visa denials, how to assess eligibility for a waiver of ineligibility, and the detailed procedures involved in appealing a visa denial. From filing a motion to reconsider or reopen your case to understanding the role of the Board of Immigration Appeals and the possibility of taking your case to federal court, we aim to provide you with a thorough understanding of your options. Whether you're contemplating reapplying for a visa or considering the complex route of appealing a decision, our post will offer valuable insights. We will also emphasize the importance of seeking legal advice and how a qualified immigration lawyer can significantly impact the outcome of your case. Join us as we navigate the challenging journey of appealing a U.S. visa denial, equipped with the knowledge and clarity to face this intricate process. Understanding visa denial reasons. 1. When a U.S. visa application is denied, the consular officer is required to provide the applicant with the specific reason for the denial, as per U.S. visa regulations. 2. This information is critical as it helps in identifying the section of U.S. law under which the visa was denied, thereby guiding the next steps. 3. Understanding the reason for denial is crucial for assessing eligibility for a waiver of ineligibility or determining the feasibility of an appeal. 4. Each reason for denial, such as insufficient evidence, fraud, or a criminal record, has different implications and potential paths for redress. 5. The clarity on the reason for denial also aids in preparing a stronger application if the applicant decides to reapply for the visa. 6. It's important for applicants to request detailed explanations of their visa denial to ensure they understand their specific situation. Waiver of ineligibility. 1. A waiver of ineligibility is a form of legal relief that allows an individual to obtain a visa despite being initially deemed ineligible. 2. Not all grounds of ineligibility are waivable, and eligibility for a waiver depends on the specific circumstances of the visa denial. 3. The process of applying for a waiver involves providing additional documentation and evidence to overcome the grounds of ineligibility. 4. Obtaining a waiver is not a guarantee of visa approval, but it can be a vital step for those who are ineligible under certain sections of immigration law. 5. The complexity of waiver applications varies, and they are typically more successful when handled with the assistance of an immigration attorney. 6. Applicants should understand that waivers are discretionary, and the outcome depends on the merits of each individual case. Options for appeal. 1. Motion to reconsider or reopen. This involves asking the original decision-making office to review the decision. 1. A reconsideration motion is based on new facts or evidence, while a reopening motion challenges the decision based on legal or factual errors. 2. Appeal to the Board of Immigration Appeals, BIA. This is a formal process for challenging visa denials based on certain inadmissibility grounds. 2. The BIA is an independent body that reviews decisions of immigration authorities, and this appeal requires specific procedures and timeframes. The federal court lawsuit. This is the most complex form of appeal and involves challenging the visa denial in the U.S. federal court system. It is a legal process that requires the assistance of an attorney and is generally used when there are allegations of the decision being unlawful or unconstitutional. 4. In all appeal options, strict deadlines apply and there are specific forms and fees associated with each type of appeal. 5. The choice between these options depends on the grounds of the visa denial, the available evidence, and the legal strategies deemed most appropriate. 6. Filing an appeal is a serious undertaking and should be considered carefully as it can be time-consuming and costly. Reapplication versus appeal. 1. Deciding between reapplying for a visa or appealing a denial depends on various factors, including the reason for the initial denial, the likelihood of overcoming this reason, and the time and cost involved. Reapplying for a visa can be a more straightforward option if the applicant can address and rectify the reasons for the initial denial. 3. An appeal may be more suitable in cases where the applicant believes that there was a misinterpretation of the law or facts, or an unjust application of policy. 4. Reapplication often involves preparing a new set of documents and evidence to strengthen the case, addressing the consular officer's concerns from the initial application. 5. The appeal process, on the other hand, is generally more complex and requires a detailed understanding of legal procedures and immigration law. 6. Both reapplying and appealing have their advantages and drawbacks, and the decision should be based on careful consideration and, if possible, legal advice. Legal advice? Then seeking the advice of a qualified immigration lawyer is highly recommended when dealing with a visa denial, as immigration law can be complex and nuanced. 2. An experienced lawyer can provide valuable insights into the likelihood of success for an appeal or reapplication, based on the specific circumstances of the case. 3. Legal counsel can assist in navigating the complexities of immigration bureaucracy, ensuring that all procedures are correctly followed. 4. Lawyers can help in gathering and presenting evidence more effectively, which is crucial for both appeals and reapplications. 5. In the case of an appeal, a lawyer can represent the applicant in legal proceedings, which is especially important in federal court cases. 6. Ultimately, a lawyer can provide personalized guidance and strategy, increasing the chances of a successful outcome. As we conclude our exploration of the challenging world of U.S. visa denials and appeals, we hope this guide has provided you with a clearer understanding and valuable insights into your options. Remember, facing a visa denial isn't the end of the road. It's an opportunity to reassess, gather more information, and approach your situation with renewed strategy and understanding. Whether you choose to reapply, seek a waiver, or embark on the appeals process, each step is a learning experience in navigating the complexities of immigration law. It's always a good idea to seek professional legal advice that is tailored to your specific case in order to increase your chances of success. Keep in mind that every visa application is unique, and what works for one person may not be the best course of action for another. Stay informed, stay determined, and approach your next steps with confidence. Don't forget to like and share our video and subscribe to our channel for more U.S. immigration videos.